A while ago, I made a video about drone laws in the United States, and one of the topics that I covered was state law. Let's expand on that topic. Hello and welcome to Legal Drone, where we talk about drones and other tech stuff. If you're new to the channel, please consider subscribing. Before we begin, as always, this is not legal advice. One of the things that I like doing is going on Facebook and read comments in drone groups, and I have seen a lot of interesting comments. I have seen things like, oh, if you're flying a mini drone, you don't have to follow any rules, and I say, wait, what? And other things that you read is about state laws and the FAA. One of the things that you read a lot is people saying no one else can regulate drones because the FAA is the only one that can regulate airspace. And as a matter of fact is that I think that that premise is incomplete and is a common misunderstanding about drone regulations. And I figured, well, it would be okay if I expand on this topic. It's a topic that I really like discussing because it involves preemption, and the preemption doctrine, when I studied in law school, it was really interesting. I really like the preemption doctrine. So for this video, I'm gonna discuss a little bit of what preemption is and what means. And if you want to skip the constitutional law class, you can jump to this time in the timeline where we get into the FAA preemption. So let's begin with preemption. Preemption is basically the doctrine where you have two government authorities, a higher government authority and a lower government authority. And when you have a law that is in conflict, both authorities have a law and that law is in conflict, what preemption means is that the higher authority law is the one that is valid, and what preemption does is that the lower government authority law is invalid because that particular topic would have been preempted by the higher authority. And in the United States Constitution, if you go to Article 6, you will find something that it's called the Supremacy Clause. And that basically says that the United States laws, treaties, and the Constitution are the supreme law of the land. And what does that mean? It means that in the things that Congress can act on, the federal government is going to be the highest government authority. So if Congress decides to act on something that they can act, then all lower governments, so states and local governments, will be preempted of approving laws or making regulations on certain topics. And that is a rough explanation on what preemption is. And the thing is that we have two major types of preemption. We have something that is called the express preemption and something that is called the implied preemption. So the express preemption, that's gonna be easy. It's gonna be when Congress, when they act on something, when they enact a law, the law will clearly state that states and local governments cannot act on that topic. On the other hand, when we talk about implied preemption, we need to look at the letter of the law to see if Congress' intention was to preempt that particular field, topic, or aspect of the law. And under implied preemption, we have three major categories. We have the conflict preemption, we have field preemption, and we also have implied preemption when we have a state law that impedes a federal objective. These categories of preemption are not exclusive. You can have cases where you have a combination of implied preemption reasons, and when you make the analysis, if Congress can act on a certain aspect or in a certain field, states' law would deem to be preempted. Because we have a federal government that it has limited powers, we need to analyze if the thing that Congress is acting on it's under their delegated powers. In that matter, we don't have any problems because the United States Supreme Court has already said that the federal government has preempted the airspace or the regulation of airspace. And that preemption, the United States Supreme Court has said that it is a field preemption. And so what does a field preemption mean? Because we have three categories and one of them is field preemption. So field preemption is basically when the regulatory scheme, and the Supreme Court loves that phrase, the regulatory scheme, it's so pervasive in the regulations that you can assume that they wanted to preempt the whole field. And the United States Supreme Court has said that that happened in regards of the regulation of the airspace. And the FAA is the administration that has the power to regulate airspace. And that regulatory scheme is so pervasive that there is no room for any state or local regulation. And that's the thing about field preemption. With other types of preemption, states can expand or they can fill voids in the law, but when it comes to field preemption, there's no even room to approve laws consistent with the federal scheme. So in 2015, the FAA noticed that a lot of state and local governments were trying to regulate drones, or they have already tried to regulate drones. So the FAA issued the state and local regulations of unmanned aircraft systems fact sheet. I have seen a few people referring to this as the preemption memorandum, and it isn't a memorandum because it is nothing that contains any rule guidance on how the FAA acts, but it just some information that the FAA gave to state and local governments for when they want to regulate drone operation. And on that fact sheet, the FAA said, not to bull rank, but we have preemption, we have field preemption over that particular aspects. And they go over what I said at the beginning about preemption and field preemption, and that the United States Supreme Court has already said that the FAA has preemption over the regulation of airspace. And we have to understand that the regulation of airspace is more than establishing limits on the airspace. We have other safety issues, aircraft operations, and all those things fall under the umbrella of the field preemption that the FAA has. But the FAA told state and local governments aspects of drone operations that they can act on. When there is field preemption, they told them, hey, look, if you're going to try to regulate, for example, airspace, you need to consult. If you want to put a parallel registration requirement for drones, you need to consult with us. But there are other aspects of state law that states still have the police power to approve law. There are four main aspects of the state's police power that can apply to drone regulations, and the first thing is law enforcement. So what state and local law enforcement department do with drones that can be regulated by the states. The second thing is zoning, and I am not gonna go that way because I don't want to give anyone any ideas of what they can do. The third thing is privacy, and the fourth thing is land use. So I'm gonna focus on those last two, starting with privacy. So states can regulate privacy and they can give its citizens a broader protections on privacy. Where I live, we have in the Constitution our privacy rights, and we have privacy rights against private citizens. I don't know in any other places, but at least where I live, we have privacy protections against private citizens. Normally, your constitutional rights are only against the government. So freedom of speech, government. Freedom of press, government. Freedom of religion, government. And the government approves law that enables those protection in society. But when it comes to privacy, privacy is such an important aspect of our law that is a right that can be opposed against private citizens. And one aspect of drone operations is that most of these drones today have cameras. They have a live feed from the drone to your cell phone where you are controlling, and that is something that is accessory to the operation of the drone. So you have a camera that is capable of transmitting images from one point to another, and at some point you will be able to see things that without a drone you wasn't gonna be able. So that is something that the state of California did. They have a law that says if without your drone you cannot access that location and you take a picture, that taking of the picture is gonna be against privacy rights of private citizens. So if you're taking a picture of someone's backyard and without a drone you wouldn't be able to do it, then you are committing that crime. And that is an example of a state law that it's about privacy. It's not about drone regulations. They are not telling you you cannot fly over that person's house. What they are telling you is that if without the means of the drone you couldn't take a picture, well then there is a reasonable expectation of privacy for that person. So you are not to infringe that expectation of privacy of that person. And this is where regulations against voyeurism comes, because a law against voyeurism is a way to protect the private citizens' privacy. It's a means to a privacy protection. Other things are harassment and all those things that yes, states can regulate, but the main topic here is privacy. So when it comes to privacy, you have to know that every state is different in regulating privacy. Some states give its citizens more privacy rights, other give less, but at least there is something that is called a reasonable expectation of privacy that it has to be protected. And that definition of a reasonable expectation of privacy is something that each state has a different view on it. And now we move on to land use. Something you probably know is that New York City has one of the most restrictive land use for aircraft operations regulations in the United States. They are using their land use power to establish landing and takeoff of aircraft. And the Department of Transportation has dedicated a few areas that you can take off and land your drone. And that is a perfect example of the land use powers that state and local government has within their limits. And that is why it's important that you look out for state and local regulation when it comes to takeoff and landing your drone. A lot of states have already established limitations on takeoff and landing of drones within state park limits. In most cases, you need a permit to be able to fly your drone in a state park. That is something that is happening in many states. California is one of the most regulated states in the United States, and the problem with California is that most of its counties are already regulating these aspects of drone operations. So you need to be in the lookout for these type of regulations because they change. You can be in one street and when you cross the street you're in another county and the law changes. So at the beginning I said that a lot of people say states cannot regulate drones because the FAA is the only one that can regulate airspace, and I said that that was an incomplete premise, and well, it is. Yes, the FAA is the only one that can regulate airspace, but there are other powers that the states never granted to the federal government, and one of them is, like I said, land use and privacy, and those things are part of drone operations, and states can put on limits on where you take off land your drone and whether you can take a picture of someone's backyard or not. Well, those things are under the police power, and that will change from state to state, and that is why you need to be aware of any state and local regulations when you are flying your drone. And that's all for today's video. If you like this video, please hit that like button. If you haven't subscribed yet, please subscribe, and I'm gonna keep posting videos like this because I love talking about law. So if you want to see more drone law videos, you can click in this box. If you want to see my footage, you can click in this box. And thank you for watching. Fly safe. See you next time.